I have seen this before, not in the headlines, not in the press conferences, not in the emergency statements released at 11 o'clock on a Tuesday night when the news cycle is already exhausted and the audience has already moved on. I have seen it in outcomes. In the slow, structural way that a legal doctrine, written quietly, decided narrowly, announced with careful language, reaches backward through time and begins to dissolve things that were considered settled. Things that courts had already ruled on, things that legislatures had already passed, things that 41 million Americans had already organized their lives around. I have seen how a single standard, applied consistently, becomes a demolition instrument, and I am documenting the moment it became irreversible. In June of 2022, the Supreme Court of the United States issued its decision in New York State Rifle and Pistol Association versus Bruen. The vote was 6-3. The majority opinion was written by Justice Clarence Thomas, and the legal standard it established, when what scholars and litigators now call the historical tradition test, did not simply resolve one dispute about one licensing regime in one state. It rewrote the methodology by which every firearm regulation in the country must now be evaluated. That is not a prediction. That is a description of what the document says. Before Bruen, courts evaluating gun laws applied a two-part framework. The first question was whether the law burdened conduct protected by the Second Amendment. The second was whether the government could justify that burden by demonstrating a sufficient interest. Public safety, crime reduction, the protection of identifiable populations, weighed against the degree of restriction imposed. It was a balancing test, applied by federal judges across every circuit for more than a decade. The Bruen majority eliminated that framework entirely. The new standard asks a single question. Does the challenged regulation find a historical analog in the legal traditions of 1791, when the Second Amendment was ratified, or in the period surrounding 1868, when the 14th Amendment extended those protections to the states? If a comparable restriction existed during the founding era, the modern regulation may survive. If no such analog can be located, the regulation cannot stand regardless of how compelling the public safety justification might be. The balance was removed. The history became the only question. I want you to hold that structural change in your attention for a moment, because what follows from it is not a matter of interpretation. It follows the way water follows gravity. It follows because the logic is internally consistent and because lower courts are now obligated to apply it. 21 states had enacted red flag laws by the time Bruen was decided. These statutes, formerly known as extreme risk protection orders, authorize courts to issue temporary orders, removing firearms from individuals identified by family members, law enforcement officers, or in some jurisdictions, employers and school officials, as posing a credible risk of harm to themselves or others. The orders can be issued on an ex parte basis, meaning the individual whose firearms are being seized is not required to be present at the initial hearing. The confiscation occurs first. The opportunity to contest follows. As of 2022, those 21 states covered a combined population exceeding 165 million Americans. Connecticut passed the first red flag statute in 1999. California followed in 2014. After the Parkland shooting in 2018, 17 additional states enacted similar legislation within 36 months. In states where red flag laws existed, researchers documented thousands of orders issued annually. California alone processed more than 1,000 petitions in 2021. All of that infrastructure now rests on a constitutional foundation that the Bruen decision placed under direct examination. Here is what the historical record contains and what it does not. The founding era produced laws that disarmed specific categories of individuals. Loyalists during the Revolutionary War had firearms confiscated. Several early state constitutions included provisions allowing the disarmament of those who refused loyalty oaths. There is documented evidence of surety laws, mechanisms that allowed courts to require individuals who had made explicit, credible threats of violence to post bond, and, in some cases, temporarily surrender their weapons. Those precedents exist. They are real. And the states defending red flag laws have cited them extensively in the litigation that followed Bruen. But here is the structural distinction that courts are now being forced to examine with precision. The surety laws of the founding era operated on the basis of demonstrated conduct. An individual had made a threat. A specific act had been performed. The legal response followed from what had already happened. It was reactive. The state moved after the triggering event, not before. Red flag laws operate on a different premise. They are predictive. The legal mechanism authorizes confiscation based on an assessment of what an individual might do, based on behavioral patterns, statements, third-party testimony about future risk. The firearms are removed before any crime has been committed, before any charge has been filed, before any adjudication of dangerousness has occurred, through the adversarial process that constitutional protections are designed to guarantee. The distinction matters because the Bruen test does not ask whether founding era laws addressed similar social problems. It asks whether founding era laws employed similar legal mechanisms. The question is not whether colonial Americans worried about dangerous individuals. The question is whether colonial courts ever authorized the seizure of property from individuals who had not yet done anything on the basis of a prediction about what they might do. The historical record for that specific mechanism is, at minimum, contested. And in constitutional litigation, contested history is not neutral ground. Since Bruen was decided, federal courts have been working through the implications with the particular deliberateness of institutions that understand the weight of what they are doing. The cases have not resolved quickly. They have not resolved uniformly. The Rahimi decision, issued by the Supreme Court in 2024, addressed the federal domestic violence firearm statute directly and upheld it. The vote was 8-1. The majority found sufficient historical basis in the surety law tradition. Justice Thomas, alone in dissent, argued that the historical analogs were insufficient. The Rahimi decision did not resolve the question of red flag laws. It narrowed it. What Rahimi established is that the government can constitutionally disqualify individuals from firearm possession when they have been formally adjudicated, through an adversarial legal proceeding with notice and an opportunity to be heard, as posing a credible threat. The Rahimi petitioner had participated in a court hearing. The process had occurred. Red flag laws in a significant number of states authorize initial orders that bypass that process entirely. The ex parte mechanism, the first day order, issued without the respondent present, without notice, is precisely the procedural element that Rahimi did not validate, and that founding-era surety laws did not employ. The historical record shows that even the most aggressive early American legal responses to anticipated violence included notice and required the alleged threat maker to appear. The state moved after conduct, not before. 21 states built statutory regimes on a procedural foundation. They built them quickly in response to visible and genuine public safety crises with broad popular support. They built them without knowing that the constitutional methodology for evaluating those regimes would be fundamentally restructured 2 years later. The laws were not built for the test they are now required to pass. There are currently, according to available court records as of early 2025, no fewer than a dozen active federal cases directly challenging red flag statutes under the Bruen framework across multiple circuits. The Ninth Circuit, the Fourth Circuit, and the 11th Circuit have all received briefing on related questions within the past 18 months. No definitive, controlling ruling on the specific constitutionality of ex parte red flag orders has yet emerged. That means the question is unresolved, and unresolved constitutional questions in the current legal environment have a direction. Draft assessments from legal scholars tracking post-Bruen litigation suggest that the ex parte provisions of red flag laws are the most constitutionally exposed element of those statutes. The ex parte mechanism has no clear founding-era counterpart. That is not a conclusion I am imposing. That is what the historical record, as examined by courts applying the Bruen standard, has produced as an analytical finding. If the ex parte provisions are struck down or substantially modified, the operational logic of these laws changes fundamentally. The mechanism depends on speed and surprise. If the individual must be notified, if they must be given the opportunity to appear before firearms are removed, the window of intervention that the statutes were designed to create closes. The risk the law was designed to address does not pause to accommodate due process timelines. The states that enacted these laws understood this. They built the ex parte mechanism deliberately, with full awareness that it represented a procedural departure from standard due process requirements. They made a legislative judgment that the public safety benefit justified the procedural cost. Bruen does not ask whether that judgment was reasonable. It asks whether it was historical. And the 1-200 petitions filed in California in 2021, the thousands of orders issued across 21 states, the infrastructure of risk assessment and court administration built around these laws, all of that was constructed on a procedural foundation that is now being examined against a standard that did not exist when the construction began. I have watched institutions build extensively on assumptions that were later removed. The building does not fall immediately. It develops stress fractures. Individual rulings in individual circuits create inconsistencies. Respondents in states where challenges have succeeded begin citing those rulings in states where challenges have not yet been filed. If the current trajectory holds, according to early indicators from active litigation patterns, the constitutional landscape for red flag laws will look materially different in 24 to 36 months than it does today. That is not a prediction. That is a description of how institutional processes work when a foundational legal standard is restructured. The Bruen decision was issued on June 23, 2022. It was 47 pages long. It eliminated a balancing test that federal courts had applied for 13 years. It replaced that test with a historical inquiry that requires courts to function as historians, examining colonial statutes, surveying founding-era legal practice, assessing the degree of resemblance between mechanisms separated by 230 years of transformation. The majority acknowledged the difficulty of that inquiry. It did not retreat from requiring it. And the 21 states that built their red flag infrastructure before June 23, 2022, did not build it to survive that inquiry. History does not announce itself, it accumulates. And when it finally becomes visible, in a ruling and a reversal, in the quiet withdrawal of a statute that no longer has constitutional ground to stand on, the people who built the thing that fell will say it happened suddenly. It did not happen suddenly. It began on June 23, 2022, in a 47-page document with a 6-3 vote, and a single question replacing the balance that had held everything in place. The question was, does history permit this? The answer is still being written. But I have seen enough of how these processes end to know that the writing has already begun, and that the outcome, when it arrives, will be described as a surprise by everyone who was not watching the Foundation. I was watching the Foundation. I'm still watching it.